Well, hello everyone. I am back from the Holy Land. I haven't seen you in a while, so I just wanted to say hello. I am today with a wonderful guest, Attorney Arthur Crooks, and we have had so many questions about the changes in the Medicaid laws, the guardianship laws, etc., and you know certainly I am not any expert. So I decided to have our friend, Attorney Arthur Crooks, come in and hopefully answer some of those questions in kind of a condensed version. We were saying earlier, he could talk for probably a full day on this subject, but we don't have the luxury of having his time for that amount. So we are going to have him on this show today and hopefully get your answers to your questions. Arthur.
Thank you, Barbara. It's a pleasure to be here. I've had the opportunity to speak at the Harwich Council on Aging before, and Barbara and I have worked together before. As I was just indicating to Barbara prior to we started here, that what I'm going to talk about today when I teach at the college and teach and give different forums and seminars could cover 18 hours. And that is just the basics. So what we're going to try and do today is hit some of the high points, and as Barbara indicated, there have been significant changes in this field just within the past year, several just within the past couple of months. So initially I want to tell you a little something about myself. My name is Arthur B. Crooks, Jr. I was also just telling Barbara that my mother recently sold her house in Harwichport and moved to La Jolla, California. The winters finally got to her. She'll be celebrating her 90th birthday in 3 weeks. I have been in my office location in West Dennis for the past 20 plus years, practicing what we call elder law, which is a fairly new term, and it encompasses standard areas of law such as estate planning, real estate, trusts, etc., in particular how they impact someone that we may call an elder. My definition of an elder is anyone over 55 and anyone that wants to become over 55. So it's quite all-inclusive. I'm local. I service the Cape. I don't have branch offices in New Bedford or Fall River. As I say, I have relationships with most of the care providers in this area. I'm also vice chairman of the Council on Aging in Dennis. I'm on the board of directors at the West Dennis Library. I thought that was going to involve picking all sorts of exciting books. It has more to do with how many light bulbs we're going to be using this year. And I also teach a course at the Academy for Lifelong Learning at the college, Cape Cod Community College, which I've done for a number of years, and I'll be doing again next semester if anyone's interested. Recently, I became a certified guardian through the National Guardianship Association, and I'm also a certified veterans benefits attorney. Now, the series of forums and workshops I've presented in the past several months have included what I call my forums, which are the basics of estate planning. And then I talk about asset protection and home protection in the event someone has to go into a nursing home, which is of great concern to people as nursing homes hit $350 a day for their charges. I've also presented a number of workshops on just discrete subjects, and those have been guardianship, special needs planning, that's for people who have loved ones with disabilities, the whole mass health Medicaid application for nursing homes, and I'm going to be presenting a final forum, a final workshop on veterans benefits, in particular the aid and attendance benefit, which a lot of people are not aware of. I have a lot of this on my website. Just remember crookslaw.com, CROOKSLAW.com. I know the name, I know the jokes, I've heard them. I live with it. I'm also a member of the National Academy of Elder Law Attorneys. I went to our monthly meeting last night, and I want to point out a few things that we discussed there. And I'm also a member of the Academy of Special Needs Planners. Now, once a month, those of us who practice in this field have a meeting, a statewide meeting. We go to Boston. What this meeting generally consists of, there'll be a theme, and then we'll review the status of current law, what's going on. This is a field, in particular with the mass health in the nursing home coverage, that changes almost on a daily basis. You really have to be up to date on it. And some of the major changes that are coming up, I just found out, are secrets. All of a sudden, they're just going to be there one day, to the chagrin of quite a few people, I would suggest. So we have to stay up on that. We're posted on all the bills in the Massachusetts legislature. There's also big things at the federal level that may or may not be happening. For instance, the federal estate tax under the present law goes away next year, in the year 2010. That is going to be changed, from what we understand, before the end of the year. Today is December 2nd. No one's heard a thing yet as to when this change will be effectuated. Last week, I attended an all-day seminar at Suffolk University Law School on the veterans' benefits. I'm going to talk about that a little at the end of my talk. But one of the things I want to emphasize before I go forward with some of the substantive material, I take a holistic approach to estate planning and all issues of estate planning, because whatever you do in one area is going to affect another area. When people come into my office, I describe it as though it's a teeter-totter. You do something good on this end, and the other end's going to go down. This morning I was thinking of Newton's basic laws. For every action, there's an equal and opposite reaction. So you have to be very careful, and you just can't pick one field or one benefit and say, this is what I'm going to concentrate on, without looking and evaluating the effects it's going to have on all other areas. And then after a careful evaluation, you go forward with what seems to be best for each individual. So, that being said, a typical call to my office will be, I need a trust, or my mother needs a will, or something like this. At that point, what I have to determine is who's my potential client here. When it's my mother needs a will, I will ask, well, is your mother competent? Is she able to speak for herself? If so, I will say, well, why don't you bring your mother in? We'll make an appointment for your mother. And if it's someone that may indicate to me that their mother or their parent is incapacitated, then we may approach it differently. So the first thing I'm going to be concerned about is what we call the basics. And I've discussed this with Barbara as to how important the basics are. What are the basics? Before a will, we need some other things in place. A will is for, by definition, after you're gone. While you're still here, you need what are called advance directives. And these consist of the durable power of attorney, the healthcare proxy, the living will, and what we call a HIPAA release. Now, one of the major changes in Massachusetts law occurred in July of this past summer, July 1st, 2009. The new guardianship law went into effect, which changes the landscape completely. It is now absolutely imperative that you have these basic advance directive documents in place, or if you don't and you become incapacitated, someone in your family is going to have to go over to the probate court and enter into the new world of guardianship law and get a guardianship for you. I've calculated that cost basis-wise, that is going to be 10 times as expensive as getting the basic documents to start with. If you do that, the chances are pretty good you're going to avoid a trip to the guardianship court. Now, from a lawyer's point of view, what's wrong with the person going to the guardianship court when it's 10 times the work equals fees? Because I don't need that. I'd rather you have your documents in place and control your own future rather than letting it get over to the court where it's going to be supervised by the court, and you may have strangers involved that you don't particularly care for or never had an intention to do. So, self-determination and avoiding guardianship. What is a durable power of attorney? That's a document that you will execute, that you will fill out, and in that document you will name people that will, if you are incapacitated, take charge of basically your finances. things to do with the house, things to do with paying bills, dealing with the banks, the insurance companies. It's very, very important that you do this, because if you don't have something in place, and if you're married, it does not necessarily mean that your spouse can do this for you. So when we call it a durable power of attorney, that means it's good through the duration of any incapacity you may have, and is good and effective up until the time you pass away. That's when your will comes into place. So when I talk about the basics, the analogy I use is we're building a house. This is the foundation we're talking about first, the basic documents. So the durable power of attorney is absolutely imperative that you have that in place. I could spend a whole hour and a half on that alone.
On durable power of attorney, a question I always get, a fear is a better question. People will say, well, so that means anytime I go into the hospital then that's going to go into effect and my daughter's going to have to take over, and she lives in California. And we counsel them that it is not when every time you go into the hospital, it's only, and it's imperative for them to know, only when they become incapacitated.
Well, that's a very good question, and especially as regards the durable power of attorney. The durable power of attorney, at least the type I use, becomes effective as soon as it's signed, as opposed to a healthcare proxy, which is the equivalent to address your health issues. Now, with a healthcare proxy, you do the same thing. You name someone that's going to make your medical decisions for you if you're incapacitated or unable to communicate with your doctor. That is determined by the treating physician. That's an on-again, off-again. The example I use is you arrive at the emergency room, you've been in an accident, and you're unconscious. Doesn't mean you're not competent, you're just unconscious. So the doctor would activate the healthcare proxy. Now, when I do a durable power of attorney, there's no conditional event that has to occur. It is effective immediately. Why do we do that? We do that because third parties, banks, insurance companies, financial institutions, they do not like doing business with powers of attorney. They don't like them. So if they can find any reason to turn it down, they will. And I'll talk about that a little more when we get to guardianship. So I do not put a condition in there. There's a very famous elder law attorney in New York called Attorney Crooks. It's spelled with a K, so he's no relation to me. He wrote an article for the New York Times a little while ago. It said, in effect, the power of attorney has the potential of being a license to steal. However, it's still much better having one than not having one, because you're going to name the person that you trust the most, be that a spouse or an older child. So when I have my client sign the power of attorney, I'll say, you know, this is sort of like a hand grenade. It's alive. You may not want to give it to your child. You may want to hold it back. But when you do give it to your child, the understanding is the child will use it when she has to use it. So it really has nothing to do with whether you're in the hospital for some kind of an incapacity. You really have to trust the person you give that power to. So that's a major difference between how a power of attorney works and a healthcare proxy. As soon as you sign the power of attorney, it's effective. Now, you can put a condition in there, only to be effective when Dr. Jones signs a letter to this effect. When you give a document like that to a banker, he's going to go, boy, I don't know about this. Where's your letter from Dr. Jones? And how do I know this and how do I know that? Massachusetts, unfortunately, does not have a law that makes it mandatory that the third party accept the power of attorney. It's discretionary. So you want to present a document that you're going to get the least amount of hesitation from the third party. So that is an issue. And obviously, you're not going to name someone on your power of attorney that you don't trust. And I also, on both of these documents, insist that we have backups, because sometimes that person is not available, the initial person you name. Another issue that comes up a lot is my daughter is in California, my daughter is such and such. Cell phones, email, you know, it's a small, small world now. And I would not let that be an impediment. If it's your daughter you want and she's in California, All my family lives in California, and I have a lot of clients. I mean, people retire to the Cape, so almost by definition, your children are going to be all over the place. And if it's a very complicated situation, they're probably just going to hire someone locally, a geriatric care manager, an attorney, an accountant. So I don't see that as a real problem. But it is something that does come up.
We do get the question, too, having the fourth highest population of Alzheimer's on Cape Cod in Harwich, one of the things I try to stress to people is to do these basics, because my understanding is that you cannot do a durable power of attorney once a person is declared with something like Alzheimer's disease. Is that correct?
That's correct. To do these documents, by definition, you have to be competent. Now, I'm not a lawyer, but when people will call me, as I indicated, my mother needs this or needs that, and I'll say, is she competent? Well, she has her good days and her bad days. After I leave here today, I'm going to be going to a nursing home. Remember, I'm not a doctor, but I have to make a judgment. I will not have a person sign documents who I'm not comfortable with, that they understand it. Now, you don't need a high level of competency to sign a power of attorney. It's somewhat higher than the level of competency for a will. But this is why it's so important to do these documents while you still can. If I have someone in a nursing home and they're there and their chart says they're there for Alzheimer's, it's going to be extremely difficult for me to go over there and execute a power of attorney or a healthcare proxy. Sometimes people will bring these documents to me already executed. I'll say, when did your mother go into the nursing home? 2 years ago. This document was signed yesterday, and when she went into the nursing home, she had Alzheimer's. That's a problem. So we can't, I won't do that. I will not do documents for anyone that I have not personally talked to and seen and evaluated and explained in person what I'm explaining here. So absolutely, you have to get these documents in place. If you don't, and Barbara and I have these cases, then you have to go to the guardianship court. And believe me,
that's not fun.
No, and since July 1st, it's been no fun at all.
You mentioned a living will. Is that something that is currently accepted in Massachusetts? I know a while ago it wasn't, and when my folks were in Florida, it was a big to-do because they said they'd already done that, and a lawyer here said, nope.
Let me just say, Terry Schiavo, the case in Florida 4 or 5 years ago, that's what brought this to the fore. Living wills are not enforceable in Massachusetts. True then, true now. What does that mean? Doesn't mean you can't have one. It just means that you can't run over to the courthouse, a la the Terry Schiavo case, and say, Judge, this is my mother's wish. She would not want to be maintained this way. Please stamp this so I can run back to the hospital with it. That doesn't happen here. A living will here is merely an indication of your wishes, a directive as to your wishes. Now, up until the Schiavo case 3 or 4 years ago, I basically didn't do living wills because they're not enforceable. Some people mix living will language into the healthcare proxy. I don't like to do that. I think that's asking for trouble. So what I tell people is we do a very bare bones living will, and if they want to add some language to it, that's fine. I'll explain that it's not enforceable, but quite frequently, let's say an older married couple, they name each other as their healthcare proxy, and one of them passes away. We have a living will in place indicating, please, no heroic measures. And the successor healthcare proxy is a child, the oldest daughter, the oldest son. And the surviving parent reaches a crisis. It's much easier for that child to make these hard decisions if they see in writing from mother, these are my wishes, I don't want any heroic measures taken. That child can't run over to the courthouse and have that stamped and run back to the hospital. But I think it makes him feel a little better when he has his conversation with the doctors and does whatever has to be done. So you are right, that is not enforceable. Doesn't mean you shouldn't have it. I do them routinely now with the understanding that it's merely a directive as opposed to something that's enforceable.
The other confusion is the difference, and you alluded to it, between living will directives, if you will, even though they're not enforceable, but at least give you an indication, and advanced care directives.
Advanced care directive is kind of a rubric that covers all of these things. And,
Like a menu.
Right, and the last thing I'm going to talk about is HIPAA. Anyone out there that has anything to do with the health field knows what HIPAA is. One of the questions we will get is, a lot of the people I deal with are retired. They're of a certain age. They travel a lot. What happens when I'm in, you pick it, Arizona, Greece, Africa, Japan, and something happens to me? How do people know about my healthcare proxy? What I've been doing is giving people laminated cards. What I will be doing in the future, I'm getting these little flash memory cards you can put in computers. With a little chain, you can attach them to your wallet or whatever. And on them, they'll say advanced directives. And I'll ask my client, what do you want on there? I suggest we put on there your healthcare proxy, your living will, and your HIPAA release. If you want, we can include your power of attorney. If you're really nervous and want to be thorough, we can put your will on there, but that's not an advanced directive. Your advanced directives are your healthcare proxy, your power of attorney, the living will, and the HIPAA. That way, hopefully, when something happens to you, they'll see it. It's bright red, and I've got them in blue also, and they'll go, ha-ha, stick it in the computer, and then it'll all come up on the screen as to who your power of attorney is, if needed. That's not that important. But on your healthcare proxy, when we fill these out for the daughter, we have the home phone, we have the business phone, we have the cell phone. Haven't gone to the email yet because these are usually emergency situations. So that's very important with a clientele that travels a lot. But that's basically what the advanced directives are. But let me hit on the HIPAA. About 7 or 8 years ago, the federal government passed a law having to do with the portability of your insurance, health insurance, that you could take it from job to job. They also tacked on the end a privacy part. That's what HIPAA stands for, Health Insurance Portability and Privacy Act. Making all your health information super secret, double probation, you go to jail if you release any of this information. People who work in the medical profession are not used to things that say if you do such and such, you'll go to jail. So they're extremely reluctant to release any kind of health information unless you can show that you have pre-authorization. And that's what we call the HIPAA release. I include a HIPAA release in the healthcare proxy. I have one in the power of attorney. And then we have as a standalone document. So once you have all those documents in place, you should be fine as far as the basic foundational documents. One other thing I want to mention on the healthcare proxy, and this is something else that came up in the Shibo case. People will always say, well, I have a healthcare proxy, I want to do what is in her best interest. This technically is not what we call a best interest state. The standard we use in Massachusetts, and I just came up against this in a hospital case a few weeks ago, is a substituted judgment standard. What that means is you're going to do or indicate to the doctor what the patient, your parent, whoever you're acting as the proxy for, what they would want, not what you think is in their best interest. They may want something done or not done that is contrary to what you think their best interest is, but if you know that's what they want, that's what you're going to indicate. If something comes up that you've never discussed, then you may use a best interest argument. But the substituted judgment is the standard in Massachusetts. So, when people come into the office, we talk about doing the fundamentals. What I brought with me is the little sheet that I use. It's still all written on paper. We still use the quill pens over there. So when people come in, I'm going to emphasize to them that we're going to do an overall view of everything, kind of a holistic approach. I keep on talking about this teeter-totter effect. So we've already discussed the basics, okay? And that's something I will be talking with initially. So a potential client walks through the door. It could be a single person, it could be a couple. Generally, I have their name. The first thing I ask them is, do you have long-term care insurance? It's the first thing I ask. 99 times out of 100, the answer is no. Okay? It's very unusual for people to have the forethought to get it when they're young or the money to be able to afford it when they're older, so you don't see it. Last night at our meeting, there was an indication that there are problems in this field. What are the problems? Same as everyone else's, money. So generally, I'm going to get a no to that. The next thing I'm going to ask, if it's a couple, is this your first marriage? Okay, great. It's not. It's your second. Oh, it's his third and my fourth. Okay. You never know what kind of an answer you're going to get. Are there prenuptials? Let's list all the kids, etc. Were you or your spouse in the military? I have a long questionnaire that I'll send out to people in advance of meeting them, but quite frequently I don't get that back or I haven't sent it to them. So I'll determine the status, if they're married, if it's a single person, are they a widow, have they ever been married? All of this feeds into the various formulas when we're doing our balancing act as to where we're going with a good basic plan for a person. I will then ask, let's assume it's a first marriage, do you have children? Yes. How many? Ages, marital status, grandchildren. Then I'll ask, are any of the above afflicted with any kind of a disability? Because if that's the case, there's another piece we have to balance into our formula, which has to do with special needs of someone in your family. I will then do a real quick rundown on your assets. Why is that? For a couple of reasons. When we're talking to you about your will, I have three major concerns. Number one, your stuff. Remember George Carlin? Everyone has stuff. So I want to know what kind of stuff you have. Number two, Roman numeral 2, I want to know what's the value of the stuff you have. If you have enough stuff, you may be subject to an estate tax. Then we have a whole other factor we have to include in our formula. And number 3, Roman numeral 3, what happens to all of the things we've just talked about if I have to go into a nursing home or my spouse has to go into a nursing home at $350 a day? So that's why I will then ask you, well, do you own your home? Generally your largest asset. When people are worried about the nursing home, that's the first thing they're worried about. What happens to my house? I will then ask you everything else. Just add everything else up that you have and give me a valuation. If you're over $1 million, or if it's a couple, if you're close to $2 million, you may have a Massachusetts estate tax issue. You may or you may not. If you're telling me your total worth is $300,000 or $400,000, I know you definitely don't. If your total worth is $1.4 million, you may or you may not have a Massachusetts estate tax problem. Remember I mentioned earlier that the federal tax may change. At this point in time, the federal tax lower limit is $3.5 million. So for a couple, the closer you get to $7 million, you're going to have a problem. Next year, as the law stands now, that tax goes away for 1 year. So all older, wealthy people, if the law doesn't change, are supposed to do the right thing next year and die so that their kids can get their estate free of federal tax. Don't count on it. That's probably going to change. The other reason I ask that the valuations is because of that pesky nursing home problem. I'm then going to ask you about your income, Social Security, pension, etc. And then we'll have a discussion of your overall objectives. At that point, I've got my teeter-totter, it's got things all over it. And then we're going to say, well, this is your objective, but let's factor this in, let's factor that in, and let's factor this in and see where we stand. So
when you mentioned nursing home, what is the number of years at this point? It was 3 years, then it was 5 years. We heard rumor they were looking at 10. What is the magic number of look back at this point?
Oh, I'm going to talk about that, and that's an excellent question. The law in this field was changed dramatically 3 years ago. And the look-back period, for those of you who are familiar with these terms, is now 5 years. And I'm going to spend a little time talking about that because that's extremely important. So we've built the foundation to the house. We've got that nice solid foundation in place. You've got your power of attorney, your healthcare proxy, your HIPAA, and your living will. I can't emphasize enough that these are mandatory at this point in time unless you enjoy spending a lot of time and money at the probate court. So now we'll talk about the will. This is the first floor. I don't think I have to spend a lot of time talking about wills because people know what wills are. Now, everybody has a will. Whether you know it or not, you have a will. If you didn't write it yourself, the Commonwealth of Massachusetts wrote it for you. Okay? So everybody has a will. But the terms that the Commonwealth of Massachusetts will provide for you, you might not like. So it's probably in your best interest to write the will yourself so that you have in there just what you want, where your stuff is going to go. Are you married? Is your spouse recently deceased? Is it a multiple marriage situation? Do you have an awful lot of money? Then you have to do some taxation stuff. One of the things that's very important when we talk about wills is not everything you own goes through your will. When I have a married couple, it's very, very rare when the first spouse dies that we have to what we call probate the will. Why? Because anything that's owned jointly does not go through the will. If it's owned by husband and wife and one dies, the other one automatically, at the instant of death, owns it by what we call act of law. This is most commonly seen with the house that's jointly owned. Bank accounts that are jointly owned. They don't go through the will. That's automatic. The other thing that's automatic is anything with a named beneficiary on it. Most often that's your life insurance. It can be your retirement benefits. Those know where they're going to go. They go right direct to the beneficiaries. They do not have to go through the probate process in the court. So with a married couple that own everything jointly and they have named beneficiaries on their life insurance and retirement benefits, that doesn't have to be probated. We would merely file the will with a death certificate at the court, no fee, and that's just to show when someone goes to look at the title to the property that one spouse has died, therefore the other spouse owns that property. And the title examiner is going to know that. And sometimes we'll even file that in the registry of deeds also. Another big thing is, I want to avoid probate. Well, if you're married and you own everything jointly, you are going to do that. Avoiding probate does not mean avoiding taxes. I'm willing to guess that Bill Gates probably is never going to have a probate estate, but he's going to have a taxable estate. So you got to keep those straight. If you've got a lot of money and you have everything set up in trusts, you're probably not going to have to probate your will, but you're probably going to pay some taxes. And again, it's what your objectives are. I'm going to talk for a little bit about trusts, but sometimes when we're doing our Medicaid planning, we might want to put a special kind of trust in the will. Ordinarily, we might not find trust to be appropriate, but in a planning situation, it may be. Then we want to know about your disabled children. What I want to talk about now is, you've heard me mention it, the new guardianship law that came into effect. I want to give you a little history. Last February 2008, the Boston Globe came out with one of its spotlight stories. And it was about abuses coming out of the Mass General Hospital going through the probate court in Boston. And the abuses were that quite frequently in a hospital setting where you have older people there and they may not have family, the hospitals want to be able to place them in outside the hospital, be it a nursing home or whatever. And to do that, they have to go through the probate court. And there was some indication that they were perhaps doing it with a little more alacrity than they should, that they were kind of rubber stamping it through. So the Globe wrote an article, and this was a perfect storm because at that time, a brand new chief judge of the probate court was coming in, and this all combined to for this new judge to say, we're going to change the guardianship system. The first thing she did in April of last year, I'm not blaming her, it's just coincidental that she was there. The most important form when you file a guardianship is what we call a medical certificate. And that's just a statement from the doctor saying this person is not competent for the following reasons and needs a guardianship. That used to be 1 page, 1 paragraph. It's now 9 pages long. It's a complete medical history. Okay. That was the harbinger of things to come. The legislature got a hold of this. They made major changes to the law. And we were appraised of it. I think I've been to 10 seminars now on it. And it came into effect July 1st. And I know probably most of you aren't familiar with guardianship law, but I'm going to try and tell you the 3 biggest changes. When someone does not have advance directives, when someone does not have a power of attorney or healthcare proxy, and they have become incompetent, they can no longer execute these documents because they lack the capacity. Someone is going to have to go over and get a guardianship. Quite frequently, if the person's in the hospital, it's the attorneys from the hospital that go over and get the guardianship. And you may have a complete stranger named as guardian if they can't find an appropriate family member. Prior to July 1st, you would go over to the probate court and say, I want a guardianship. And the guardianship had 2 prongs. One was for financial stuff, similar to the power of attorney. The other prong was the health care prong to make the medical decisions. And you just get the 1 guardianship with the 2 prongs, not any longer. Now there are 2 complete separate cases, so to speak, you have to start. So if you have a person that needs to have their medical decisions made for them and they have some money, you have to go over and get a guardianship and a conservatorship. Each one has multiple new multi-page forms. So instead of just filing 1 case, you've got to file 2 separate cases, and the paperwork is staggering and overwhelming. And of course, with the financial crisis, staff at the court has been cut back. They're not replacing them. And in the midst of all of this, they instituted a new computer system called mass courts. So the perfect storm occurs. Now, the other thing they did, and I filed a couple of these things, they take a day and a half, whereas before it might have taken a couple of hours. So that's where your increased fees and work comes in. And the court is highly solicitous of what we call the incapacitated person's welfare, and you have to have all sorts of hearings. The other thing they added in, which you may be familiar with now, is that if you have an incapacitated person and you want to place them in a nursing home, you now need special permission of the probate court. And this is causing all sorts of problems with nursing homes. It's causing all sorts of problems for people that we have to get guardianships for, and we know 95% of them are going to be going to a nursing home. We have to get special permission from the court. And this goes on and on and on. Now, that's just the good news about the guardianships. Now I'll give you some more. Let's say you're the loving child and you get to be appointed a guardian. In the past, there were all sorts of requirements that you had to file certain things. Basically, they were never enforced because there was no mechanism to enforce them. Under the new guardianship rules, they've added on a lot more reports you have to file, a lot more of the accountings you have to file. But remember that new computer system I told you about? You as the new guardian or conservator will be in that computer system, and they will keep track of you. And if your report is not in the day it's due, you will get a letter. In other words, the burden on the person that becomes the guardian is going to be actually enforced, whereas it never was before. Therefore, if you want to get involved in this system, and these things are reviewed every year, every time you want to do anything of significance, you have to ask permission of the court. So please get your basic documents in place, and then hopefully you'll avoid that. Any questions, Barbara, on the guardianship?
I don't think so. I think one of the discrepancies or one of the confusions was between guardianship and conservatorship before.
The conservatorship was always there, but it was a rare bird. For every 200 or 300 guardianships, you might have seen one conservatorship. Now, the only thing you don't have to duplicate is the medical certificate. They will let you use the same medical certificate. And let me mention one other thing. There are gray areas. The gray areas have greatly enlarged. When I do my basic documents now, I have since July 1st, I've had to amend them to include a lot of things on the healthcare proxy to avoid guardianship situations. You're not going to find these on the standard thing you get at the hospital. They don't have them. I have language on my healthcare proxies such that hopefully it may be used in a situation where certain medicines are used. You may have heard the term a Rogers guardianship. Certain medicines, if they're going to be used in the Commonwealth on an incompetent patient, you may need special court permission. You may need special court permission for an extraordinary medical procedure. And that can be anything. That's kind of a nebulous term. And in the past, you needed permission to admit or commit someone to a locked ward. And that basically means a state hospital. It's not the Alzheimer's unit. That no longer is done in the probate court. That has now been shifted over to the district court. So in the best case scenario, you may have 3 cases going now, 2 in the probate court and 1 in the district court. I've also added onto my healthcare proxy language saying I hereby authorize my healthcare proxy, if warranted, to put me in a nursing home pursuant to, and I put all the language from the statute. And then at the end, I also put in, I also authorize my healthcare proxy to do a DNR, do not resuscitate, or other advanced directive. So the more you can get in that healthcare proxy that addresses specific issues, the more likely you are to not have a problem and wind up in the probate court. So it's a very tricky area. The last seminar I went to had a number of judges and the what we call registers of the court, and people would ask questions, and the judges and everyone would go, "We never thought about that." This thing is changing. There's some major changes that have to be made, but it'll take at least a year to make them, because that's the way legislation works on Beacon Hill.
I will tell people, too, that Jill is always kind enough to make copies or DVDs of these talks for seniors who are watching. I know this is complicated information and not something you're going to be able to digest in one sitting. And I know people are probably sitting there trying to write fast and furious. So this program will be available for people to borrow. So not to worry, and don't feel you have to take notes unless you want to send them to your children.
And again, we're just hitting the highlights. You can always contact my office, and we have a brochure that's growing by the day. It's got 7 or 8 inputs in here, and if you go to my website, I cover a lot of these areas too. Now, we're sort of in the final lap now, so I'm just going to hit a few more topics. What we get a lot is, I called you because I need a trust. Why do you need a trust? Because my friend has one, okay? Professor Maitland, a famous professor from years ago, said that the concept of the trust is the greatest invention of the common law. Probably true. But there are a million different types of trusts. This is not one size fits all. And this is one where you've got to be real careful, or the law of unintended consequences will bite you big time. So I'm just going to hit on the different types of trusts. There's revocable trusts. Those are the ones when you go to the nice seminars and you get the nice meal, and they're going to present a package of documents that will solve all your problems. They're probably selling you a revocable family living trust so you can avoid probate. That's very good. However, if you ever find yourself in a mass health Medicaid situation, that's very bad. Okay, so you don't know. In the revocable trust, is as it implies, you can undo it. You can revoke it and say, I don't want it. There's the irrevocable trust, which my analogy is the strong box. That's irrevocable. You open that up, whatever you put in and you lock it, it's there, non-revocable, and that has a lot of play after the new Medicaid laws came into effect. There are ways of getting out of it, but it's very difficult. There are testamentary trusts. Those are trusts that appear in wills. The trust is a creature of the will. And then the other way of creating a trust is during your lifetime. That's called, in the legal term, is inter vivos. There's a whole other set of trusts, and I'm only going to name them, that have to do with people with disabilities and special needs who are on SSI or SSDI. These are very effective, very good trusts. They provide for disabled people, and they don't have penalties associated with them for both the person that's getting the benefit of the trust and, in many instances, the person that established that trust. And these are called, I'm just going to give you the names, a D4A, that's after the federal name of these trusts, a third-party trust, and a pool trust. Pool trust, there's a big change coming. That's the one they're keeping secret. So again, I'm just going to hit on this. Now, let me talk about the big changes in the Medicaid rules. The Deficit Reduction Act of 2005 was passed it's about 3.5, 4 years ago. It was an attempt to address perceived abuses in the Medicaid system. The people driving the Cadillac up to the door of the nursing home and waving goodbye to the children who are driving away in the Mercedes cars that the parents had just given them. I've never had one of these clients. I don't know where they are. But what happened is, in the past, when you applied for assistance with the nursing home, why would you do that? Because here's how nursing homes get paid for. If you go into a nursing home and you've been in a hospital for at least 3 days, it's called the 3 midnights rule, Medicare will pay for up to 100 days, period. That's the only coverage you're going to get from Medicare for nursing home. Then we go to long-term care insurance. Very, very few people have that. Then out of your own pocket, $11,000 a month. That's a big chunk. Then we go to the payer of last resort, which is Medicaid. In Massachusetts, that's called Mass Health. It's a federal program, and it has state regulations. The head speaker last night was from California. California has yet to put in their regulations for this law that was passed 4 years ago. Massachusetts put them in right away. So we're operating under those laws. In the past, when you would apply for Mass Health, they would have what's called a 3-year look-back period. That means they would want to see everything you've done of a financial nature going back 3 years. You can't just give all your money away and say, I'm poor, pay for me. They're going to go back 3 years. Now they will go back 5 years, which gets problematic because when you're dealing with people of a certain age, maybe a widower, to get very detailed records going back 5 years can be a problem. Recently, we had a bill passed that if you're doing this and you have to get a bank to get the records for you, the state will pay for that. However, by far the more important aspect of this was the way they imposed the penalty when you do give money away. And you know what giving the money away usually is? And I had a woman in yesterday. It's giving a certain amount of money for your grandkids' college tuition. Okay, a wonderful thing to do. But $35,000 2 years ago, that is a disqualifying transfer. It's a nice thing to do, but as far as Mass Health goes, that disqualifies you. Under the old system, you could run that penalty out. Under the new system, you can't. Your penalty comes into effect when you're down to the poverty level, which is $2,000, which is the level at which you qualify for Mass Health. This is causing endless headaches. And people have to be aware of these rules because you're doing something now, and you're not planning on 4.5 years from now, I may be going into a nursing home. It's probably the last thing in your mind. You just want to help the kids out or the grandkids. So you have to be very careful. Also, a lot of the things you can do are based on being married. If you're single, there's very few things you can do, and one of the few things you can do is what is called a pooled trust, and I'm not going to get into what it is because they're going to do away with it, but they're not going to tell anyone. One day we're just going to wake up and it's going to be gone. But someone found out about it. So when people come into the office and are concerned about this, this is a whole other field. We're talking about the house, how to protect the house. A house is basically a non-countable asset. Means they're not going to hold it against you that you have it unless you put it in one of those revocable trusts. That makes it countable. That's why you have to be very, very careful when you get those revocable trusts. You've been to the nice seminar. If you put your house in there, you're playing with fire. So you have to be very, very careful. Then we have countable assets, non-countable assets, spend downs, annuities. I have a list here, a checkoff list that I use. This is dated March of a year ago. It's already hopelessly out of date because of these changes. So I'm not going to go into that a lot. I've already mentioned estate taxes. If you have over $1 million, that's the Massachusetts level. That is not going to change. All the changes in the 2010, that's strictly federal taxes. So don't worry about it. But if you got the $1 million. Now, a few years ago, when our house values were really nice and high, a lot of people were hitting that $1 million pretty easily. With the drop-off in value of houses, you're not seeing it as frequently as you used to. Now, the last thing I'm going to mention is, remember, I told you at the beginning, I went to a veterans benefits seminar all day at Suffolk Law School last week. The one benefit that they talked about, and it's the only one I'll be talking about when I give talks on this subject, is something called aid in attendance. It's a wonderful benefit. Not too many people know about it. And it's particularly helpful if you live in assisted living. And very, very briefly, what this is if your unreimbursed medical expenses exceed your income, you're entitled to this benefit, which can be up to $1,800 a month. Now, when I opened my paper yesterday, one of those little flyers came floating out. Someone's going to give a talk about this benefit, which is wonderful. And it has other restrictions similar to Mass Health. There's an $80,000 asset cap, which you can get down to $30,000. But this is an absolute minefield because a lot of the things you can do to qualify for this benefit are going to disqualify you from Mass Health. And a lot of these things that you would do, you can't fix. So let's say you're in the assisted living. Why is it so helpful in assisted living? Because due to the quirks in the veterans law, the whole cost of your assisted living, be it $5,000 or $6,000 a month, is considered a medical expense. So it's going to, if you're in assisted living, it's going to be very easy for your unreimbursed medical expenses to exceed your income. Therefore, you're probably going to qualify for this. But there may be some other things you have to do with the assets, which you can do under the veterans law. But if you do them, they're going to be disqualifying transfers, and if a year after you get this nice veterans benefit, someone has to go into a nursing home, you're out of luck for 4 years. So this is a minefield. It's a great benefit, but you've got to be extremely careful. Which brings me back to my beginning. Put that foundation in, that's essential, then build your estate planning house. But every single thing you do has an effect on some other part of it. So in total, after we balance everything out, we'll have some suggestions with the caveat that this stuff changes all the time, but all we can do right now is that which protects us at this time. And the absolute given, if there's one thing you take away from this, is you've got to get those basic documents in place, or you too will become overly familiar with the probate court.
Thank
Anything
you
else?
so much. No. I'm sorry that we're already out of time, but as I said, we will have this available for people to borrow, and we certainly will have Arthur back. I use Arthur as our Medicaid expert because, as he said, you can blink your eyes, and what we've just talked about today, next month, may have some changes again. So thank you so much for coming, and Please stay tuned, and if you have any questions, you can certainly look at the DVD, and we will have Arthur back to update us again in the near future.
Thank
Thank
you.
you for tuning in.
It was my pleasure. Thank you again. That's it.
That's
Oh, you bring such wonderful.
Oh, and I got to